What is the single most significant presumptive condition created by the PACT Act?
If you're just talking about presumptive condition, that's certainly going to be a lot of the respiratory issues and cancers that were added for the Gulf War vets. But there are a lot of very significant portions of the PACT Act that affect all kinds of people, including widows with the Survivor's Clause. It's very significant for the Vietnam-era veterans that served in Thailand and in other locations. And then also, again, it's really significant for the Gulf War with all the cancers and the respiratory conditions.
For veterans who served at Camp Lejeune or Fort McClellan, what is the current status of those healthcare claims?
So the PACT really didn't change anything for Camp Lejeune or people that were at Fort McClellan. The PACT Act did direct VA to do more investigations into Fort McClellan, and then they're required to do follow-up like every couple of years and provide a report to the secretary on Fort McClellan. But unfortunately, Fort McClellan is still not listed as a site that has any kind of Agent Orange or herbicide exposure. But a lot of times we do see concessions to the PFAS and things like that, which are also toxins.
Of those claims, which would you say are the most successful ones?
So just given the history of it, I would certainly say Vietnam-era Agent Orange exposure, especially with the addition of the other locations, just because of the amount of time we've been working on those and the development that VA's made, and those claims have been around a lot longer. We may see it kind of level out, but at this point, success is really just more based on how long these claims have been out there.
What should a veteran do immediately after receiving their toxic exposure screening?
So toxic exposure screening is something that happens when you're visiting the doctor at the Veterans Health Administration. So when you go see the doctor, and it's a short survey. It'll just ask about your military and some of the exposures you may have, and then identify some of the things clinically that could correlate to those exposures. But there's also another test called the Military Environmental Exposures Assessment, and that's something that you can ask your provider for, and it's a much more in-depth discussion on the types of exposures you may have had because of your military service and also the clinical implications of it. So that's something you can talk to your provider about and see if they're able to perform that for you in addition to the TES, so the toxic exposure. So even if you don't have a condition right now that is presumptive or that you can link to those toxic exposures, it's important to know that you have them first. So if anything shows up, but if you do have some conditions that are linked to it, you can use that somewhat as evidence for your compensation claims when dealing with the BVA.
Many veterans were denied toxic exposure claims before the PACT Act. How do they file a supplemental claim to benefit from the new law without restarting the process?
So unfortunately, since they've claimed before, they're not going to be restarting the process, but unfortunately they do have to refile for those benefits. If they had filed within a year of 2022, obviously the effective date would have gone back to 2022. We're out of that kind of honeymoon period right now, but they would need to file a supplemental claim and just note on there that they believe that it's a PACT Act claim.
And now with those claims, are they able to get anything that's not presumptive?
Of course. The PACT Act just helped expand the locations of presumptive exposure, and it also added presumptive conditions, meaning you served in these places, you have these conditions, really you don't need any other information or any other evidence to prove the claim. If you served in a location that there are known toxins and you are conceded to be exposed to certain chemicals or whatever it might be, you can always try for direct service connection, meaning you can prove that the condition you have now is due to those exposures that you had. It's a little more difficult, but it certainly doesn't foreclose on getting benefits. Also, if you have a condition that's secondary to a presumptive condition, those also are obviously not presumptive, but if you do get service connected for that presumptive condition, it can open the door for you to file for secondary conditions.
So what about veterans who had short deployments in exposed areas? Does it matter for that? Is it the amount of time you were there or just that you were there?
So for Camp Lejeune, that's one where there is a minimum requirement for how long you were there. For Vietnam-era veterans, just one day exposure, just being there for 20 minutes in those locations gives you that presumption. Obviously, the longer that you're deployed, the more exposures you're going to have, but that doesn't necessarily foreclose on you not being exposed.
And then what is a conceded exposure claim?
So conceded means that VA, based on your service records, is going to say, yes, you were exposed. An example of this is if you served at Camp Lejeune between the years that they say that there was a toxic exposure, they're going to say, okay, yeah, you were definitely exposed to these chemicals. For Vietnam-era veterans, it's the same. If you were in any of those locations, they're going to say, yes, you were exposed. From there, once exposure is conceded, then those presumptive conditions automatically become service-connected. You may need private medical opinions when it comes to figuring out your effective date or the severity if you're rated too low and things like that, but you may just get service-connected even if it's at 0%. Sometimes the medical opinions can help with other aspects of the claim. And the medical opinions now, even if it's a non-presumptive condition, say they concede your exposure, but you have a non-presumptive condition, we're still using medical opinions in those situations in order to get service connection. One of the big things that I don't think a lot of people really know about, and it was a really big clause in the PACT Act, and it specifically deals with survivors. So one of the parts of the PACT Act that I think is really impactful to a large group of people that they just may not be aware of, or even if they are able to get the benefits, aren't aware of these provisions that can help with a whole lot of retro payments. So there's a survivors clause in the PACT Act that specifically deals with Thailand or veterans that we now know were exposed to Agent Orange outside of just Vietnam. And the clause says that if you previously filed for DIC and you were denied because they couldn't prove the exposure, when you refile with PACT and you get that presumptive, the effective date goes back to the first time you filed. And it's one of those little things in there that people just may not know about. And so even if you get your DIC granted, if you've ever filed before, try to get that earlier effective date.